What's up to my people out there? Darrell Brooks, day 10, I think. I know we're calling it day 10 recap. I can't remember what day it actually is. We've already got some new members joining us tonight. Alyssa Hendry, Saloa Brown joining the membership crew before we even start. Now that's dedication. That's a channel community right there. And I've seen a lot of people commenting about the community, the chatters, all that. It has been so nice. All the encouraging words to me, to each other, to everybody. Melanie here, hoping we get to 6K tonight. That would be fun. That would be wild. But I got to be honest with you, it would make sense with how crazy this day in court was today. And what did we learn in court today? What happened today? Because it really is, I learned so much every time we try a case. By the way, my trial that was supposed to go Monday, it looks like it's getting continued, which is very annoying, but it happens. It's part of the game, and unfortunately part of the reality of being a trial lawyer that makes it difficult and stressful to have to re-prep these trials so many times, but that's okay. Today, we learned even more about the law, about this case. We learned what the jury view is like in these situations. It can be very different depending on if it's a Nicholas Cruz type of case where they go somewhere, or if it's this type of case where they're actually looking at something specifically and they really don't have to go very far. We watched today potentially the final nail in Darrell Brooks's coffin. We will get to that, what I think that was. But we also saw perhaps his biggest aha moment of the trial that he has been fighting for and trying so hard to prove the entire trial. He got the answer he wanted today, late in the day. We will get to that. And also today, which is kind of showing how you can be conflicted or have a roller coaster throughout a case or a feeling about a defendant or arguments or different parties or lawyers in the case. I actually thought that Darrell Brooks made some of his best arguments today, which we'll talk about. He made some very fair points that I think were totally appropriate to argue, and he successfully argued some of them. While also today, I thought was potentially some of the most reprehensible conduct I have ever seen in a courtroom and disrespect I've ever seen towards a judge, where the judge actually kind of took it and didn't react the same way a lot of judges would. And I hate to say, I probably would have too. This dude would not be sitting in my courtroom anymore. He'd be watching from another courtroom on mute, holding up an objection sign. And he deserves to be there, in my opinion. But this judge, who's better suited than I for this job, clearly, keeps him in the courtroom. We will break down, recap the witnesses today. Some of them are kind of quick and not very exciting, not a lot to recap, but we will be watching clips of the trial. We will be watching the clip that you all want to see. Don't you worry. I am sure that people are asking about, yes, New York Mom. I knew it would be in here. Please talk about him yelling at the judge today. Don't you worry, John O'Rourke. We will talk about whether or not Mr. Brooks is a real man. And nobody's going to talk to him like that. Nobody's going to tell him what to do as he sits there with shock collars on his legs. Just imagine what you'd have to be like and what state of mind you'd have to be in to think that you are a man, you have grown kids or whatever he said, while you have shock collars around your legs with law enforcement officers not letting you move 3 inches from where you're at, but you can still pound your chest and yell at a female judge. Not a good look. We will get to that today as well. But first, if you guys haven't, take a second, hit that subscribe button. A lot of new folks here from the Darrell Brooks trial. There are a lot of cases coming up, a lot of cases we have done. If you want to check them out on the channel, we'd love for you to be along for the ride. Give us your opinion, give us your questions, add to the content, because all you are potential jurors wherever you're at. And a lot of you are actually coming from Wisconsin, which is cool because you give us an insight. I actually spoke to somebody from that area today about a potential car accident case. And it's funny just to hear Wisconsin in his voice. You know, it's such a nice, friendly, voice up in Wisconsin, and you're letting us know what jurors in that area would potentially do in a case like this. Maybe different than Florida jurors or California jurors or New York jurors, right? So that's what makes this real cool about having a cross section of society in here to discuss these cases, and specifically this case, and what's going on and what the questions are and what the jury may think. Because a lot of people are still wondering what the jury may be thinking. And we have our ideas, but we don't know for sure just yet. So hit that subscribe button if you want to come along for the ride. Like the video if you haven't already. We got a ton of likes on last night's video, so that's always really fun and nice to see. And yeah, Henhouse Bathco found us on Depth View Heard and stayed for the reactions and has loved it, which is awesome. And we love you too. And all of you who come and join us for all this content. So hit that like button, subscribe to the page if you haven't already. I see a lot of people, Kat, asking about that suitcase killer trial, which we can. It's hard for me to follow multiple cases while the trial is going on, while I'm working. I will overwhelm myself. So I can't do that. I'm probably just going to focus on Brooks for now. I need a break, really, is what I need after all this trial prep. But I'm going to follow Brooks for now, and then whatever's next will be next, and we will discuss that together. So at the very beginning of the day, Brooks talks about how he does not want to go and be at the viewing because he thinks the judge is forcing him to be there. But then the judge says, I actually changed my mind. I thought about it, and I'm going to grant your request. Then he fights her about granting his request. So what's interesting is this is one of the issues I have had with this judge is there have been certain points where she tries to get him to make the right decision. Like yesterday, I think at the end of the day, she tried to say that it would be this big deal. They'd have to go through this colloquy. He'd have to sign a paper, and, they'd have to do all this rigmarole to get him to waive. But then she's like, actually, I don't have to do that. And he's like, wait a second. I thought you said we had to do all of this. And that's the problem. She was actually trying to make it seem like such a big deal, something he's not going to want to do. And then when he still called her bluff because he wants to be as difficult as possible, she backs down. And then after she says, okay, fine, I'm going to let you waive, he said, well, that's not fair. If I have a right to be there, then you shouldn't be able to do it without me. And she's like, no, sir, we're doing it. So at the end of the day, he ends up going. He ends up agreeing to it. They find a way to not shackle him. We'll talk about that jury view a little bit later. But the judge knew he was going to fight her no matter what her decision was. So she figured out a little reverse psychology and said, you know what, fine, don't come. We'll do it without you. And we'll let you know how it goes. And then he says, actually, I need to do it. Bodhi said she needs to consult a teacher. That is kind of what it feels like, right? And the judge let him go back and forth for far too long before the state stepped in. And I really think she's giving him a little too much leeway and a little too much courtesy at this point. You give an inch, they take a mile. Somebody said that about a parent's child relationship. And that's what it feels like here. He's going on and on about the plaintiff stuff. She gave him a written subject matter jurisdiction. He's still arguing about it. He is never going to stop. Rosebud said, we are hashtag Waukesha strong. Yes, a lot of you in here, and we love it. So a lot of issues, a lot of comments coming in. We'll put some of the either funny comments up there, the quotes from the trial, a ton of new members. And we're going to do probably next week, since this trial is off, I'm probably going to do that membership top 10 breakdown, subscriber only view, members only chat. Everybody that subscribes is welcome, of course. Just a little boost for the members next week. But the first witness was the IT director of the school, talked about where the school cameras were. He gave them to the police. Then people who lived in the area that gave their footage to the police. He asked them all pretty much the same questions on cross. Who's the plaintiff? Have you seen this video before? Who subpoenaed you? You've talked to the state. Do you see a plaintiff? Blah, blah, blah. Nothing really crazy came out of any of those witnesses. Then the first law enforcement officer took the stand and talked about canvassing the area where he found the sandals and the sweatshirt in the play area for the kids. It's embarrassing. That's the point, is how Darrell Brooks can sit there with a straight face while they explain how he thinks he's playing some trick. Like it wasn't him because the guy in the car had a gray sweatshirt and I was wearing a red shirt. It's like, well, we found your gray sweatshirt when we saw you run through these backyards and we saw you throw your shoes off We found all of that. Now, he didn't ask if the people that lived there, if it was their gray sweatshirt, which was again, we're going to talk about a couple good points Darrell Brooks made today, and that's one of them. Why didn't you knock on the door? Say, maybe it was their kid's sweatshirt. Maybe it was the dad's sweatshirt. Maybe that's their son's shoes. And the cops didn't even do that, which I thought, probably should do that. I think you should do that. So good point. Does it matter? Does it make him not guilty? No, but it was a good point. And we're going to point out the good points when Darrell Brooks makes some. And then he objected to leading questions, and they were leading, but they were to lay foundation. Like, you usually do this when you canvass a scene, okay? And you set up the scene like this, and you do that. So they lay the foundation. You're allowed to ask leading questions usually as lawyers. It's kind of a courtesy. Don't object to that. But he did object, and the judge overruled it, which I actually think is legally improper. They should not have asked leading questions. And this is some of the weird stuff. Like, the judge is lenient with letting him go off and say stuff in front of the jury and be disrespectful to the judge sometimes. But then she is strict with him and not sustaining his objections when he objects properly to leading questions. Why not just force the state, who are professional attorneys, the actual DA, just make them not ask leading questions? Like, instead of saying you do this to set up the scene, say, how do you usually set up the scene? What do you usually do this? Not a big deal, not reversible error, but just kind of the way I would handle it if I was the judge on the case, which I think is just interesting. The second cop that took the stand, he's the former Air Force officer, which is always an extra ticket. And thank you to everyone out there that's in the chat. If you did serve in the military, let me know, because thank you for that. And whenever we have a witness or a law enforcement officer, anybody that is a former military officer, we like to let the jury know, because it's an automatic respect and makes you more believable as a witness. Darren Smith, thank you. Stephanie, Cass, AJ's, Randy. Man, this is awesome. A ton of you. Nicole, Allison, a ton of you guys. Thank you for that. So they start out with that, which is always good, gives instant credibility. He's the one that, kind of pieced all the video together to tell us exactly where Brooks went on car, by foot. And, he clipped it all together. And of course, he's seen it before. But then a flashback to the Johnny Depp Amber Heard trial. I had a flashback. I don't know if you all did too. And we're going to play a little bit of that so that you can see that, they used to do the thing like, maybe they're just like us. Celebrities, they're just like us. It's like, criminal defendants, sometimes they're just like us. And Darrell Brooks noticed this officer doing something that he felt was strange, and he decided to call him on it. So I don't know if any of you remember. Yes, Joni remembers this part of the trial, but let's watch it together. I just found it interesting.
All right, you can begin when you're
Wait,
ready.
not 2 times speed, Peter. We got to slow it down for the fam here. All right, here we go.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation.
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
I'm sorry, I did not hear the question.
He looks genuinely confused, to be fair. Darrell Brooks looks genuinely confused. I don't think he actually is, but he does look confused.
Repeat your question.
Well, I was referring to when I asked a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor.
It is a question.
We did ask a question about that.
Yes.
It was a question.
I think you're asking why does he do that to that extent, the witness thinks.
I'm here to present the case to the jury.
So,
Yes, Mo. Back talking the judge is very uncomfortable. So he says, I'm here to present the case to the jury, right? And I think that's fine. I'm answering, and my information is here to help the jury, which is, in fact, true.
I follow that fundamentally.
I follow that fundamentally, but not.
But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or
Objection
being
not
asked,
negative.
rather?
Assumes fact, not evidence. Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative.
Beat it to death.
Evidence. Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the
This is
relevance.
an-
Grounds.
This is another interesting part. And this is why you decided to testify. He's trying to make all the witnesses seem biased, especially the law enforcement officers paid by the state. The state's the plaintiff. We know all that. But he really steps in it here because he doesn't understand how the subpoena process works. He doesn't understand why the state subpoenas witnesses and why they don't just show up. It's for this exact reason, so they don't look biased. And defense attorneys know that. So if they're going to try to make them look biased, they will pick other ways. But he steps right in it here because he's a pro se litigant.
Will the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor. Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Grounds.
Sustained. As to the form of the question, please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
The objection is sustained. Let's go back and ask the question.
And in case you didn't watch the trial today, or if you don't watch it any day, you just come for the recaps, A-okay, that's what we're here for. But this brutality happens so often where they go back and forth on objection sustained. Well, what did you not understand about the question? What was not understandable about it? Well, did you understand my question? What question? Can you read back my question? So much of the trial is like that.
Jen, that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection, relevance. Okay, let's let Mr. Brooks get the question out. Go ahead, Judge. I thought that was it.
Are you testifying
And remember that scoff, that because the judge counts them.
today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds. That's what he said.
Grounds, that's what he said. Not a proper response. Hey, you heard what from who? I refuse. I refuse to do that.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said.
It's testifying now.
So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor. Please rephrase the question, sustaining the question asked as to the form of the question.
And there's more coming that's legally interesting to me that we'll break down. So follow with me here. Track with me here.
I don't know how I'm supposed to rephrase that without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision. Sustained as to the
So there you go. And the state tried hard. The DA tried hard not to do it. But at the end of the day, she just had to tell the witness the answer. The answer was it wasn't his decision. It is a bit coachy. We would complain about it if Amber Heard's lawyers did it. So we've got to complain about it if the DA does it here. We'd complain about it if Johnny Depp's lawyers did it. We'd complain about it if Darrell Brooks did it. So we got to complain about it if the DA does it. She's telling the witness the answer. And you know how we know that? Well, let's hear what the witness says.
form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Hopper from the Waukesha County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
Oh, why don't you believe it's your decision, sir? Could it be because the DA just told you it's not your decision? Ta-da! That's how it works. But what's interesting is he's right. The DA's right, obviously. But Darrell Brooks doesn't stop there, I don't think, if I remember correctly.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
Boom. There it is. It'd be fair to say, his crutch, that you didn't have to show up. It's like, actually, sir, no. If I want to keep my job and I don't want to get thrown in jail, if I get subpoenaed by a court of law, by the DA, I have to show up. Just because I'm a cop doesn't mean I can ignore a subpoena and not show up. That's not how it works. So he stepped in it, you know? I mean, that's just, there's no other way to say it, but he stepped in it. All right. So then we get to a type of witness I'm very familiar with and happens in a lot of car accident trials, as you can imagine. It's basically an accident reconstructionist. It's a mechanical expert, mechanical inspector guy who looks at the car, sees what's wrong with it, looks at the brake, probably looks at the black box data if it has any. He inspects it to see how things were working, what was operational. He goes through it and says there's a lot of damage to the front end, obviously, but he gets to something that I referenced in the beginning of the video, and what I think is the final nail in the coffin of the argument that something went wrong with the car. We heard Daryl Brooks say, what if a gear got stuck or the brakes didn't work, or if they couldn't stop? They were honking the horn, but they couldn't stop the car. We heard another witness say, sir, you could have just stopped the car and gotten out. You could have backed up. You could have gone the other way. You could have gone through the barricades at a different spot to not hit any people, as opposed to hitting people. Well, all of that has been leading to this witness who is going to scientifically eliminate that as an argument for Daryl Brooks. It is gone. And while you can kind of argue certain things by questioning it without actually saying it, which is how Daryl Brooks has been making this argument, he hasn't said that there was a mechanical issue or that the brakes didn't work, but his arguments and his questions definitely feel like that. And after we go through this clip, we will answer some questions for the first Q&A portion of the video.
And then pressing together a couple of inches. Go ahead.
Are there any other components to the braking system in a car?
Objection, lady.
There's a parking brake system in the vehicle.
But other than that, so you covered every aspect of the braking system in this particular vehicle, is that correct?
Objection. Respectfully to you.
Overruled. The witness may answer.
Yes, I have.
Did you observe anything at all that would have prohibited this vehicle from stopping if the brake pedal had been applied?
No.
Nice pause to make sure that sinks, because that hits
Anything
hard.
that you observed or documented during or in your mechanical inspection report that would have contributed to the crashes that this car was involved in?
Objection.
Overruled. The witness may answer.
No.
Thank you.
Thank you. Any crosses answer?
So mechanically speaking, nothing wrong with the brakes, nothing that caused this accident, no gear lock, no issues with this car, mechanically speaking, from an expert. John asked a question. Is it a leading question if the witness is an expert in their field? Yes, it's still a leading question. Now, like I said, most courts will let me say, tell us your education experience. You went to law school here. You went to medical school here. This is your training. Like, you can lead them down that path usually, and it doesn't matter. But in this case, in an abundance of caution, which this judge is absolutely doing in most other things, I probably just wouldn't let any leading questions fly, personally. So some interesting questions about high beams and things like that. But before we get to one of the outbursts, let's answer some questions. The Spose AZ is a new viewer. Awesome and welcome. DB seemed over the line today. Absolutely. We haven't quite gotten to it yet. Giggle in SC. I've never yelled at my computer more than today. It was literally all day. My husband is homesick and said, is that what you do while I'm working every day? I just laughed and said, it's not normal. I'm not normally so vocal, but yes. I didn't yell at the screen today, or I wasn't even watching all of it, but when I listened to it on 2x speed, I was like, is this guy serious? Like, I want to save some of it for the outburst, but I'm like, this is the real Daryl Brooks. And I almost wish the jury would have seen this. This tells us everything we need to know. The guy in the police interrogation, the guy that's putting on a show here in the courtroom, I don't think that's Daryl Brooks. I think we saw the real Daryl Brooks today, and we'll get to that a little bit later. Lil K, newer to the channel, love the content. About 15 minutes from the court. People of Wisconsin are very invested. We want justice. Army vet, thank you for your service. Thank you for bringing a voice here from Wisconsin. That is awesome. All of you. Appreciate it. Melanie Casio. Melanie, I get getting rid of the hoodie, but why the shoes? I asked myself the same question. How many dudes walk around in slides? Hundreds, thousands, millions? A gray sweatshirt, I get it. You know, you want to trash that. But, like, why get rid of – they're not going to ID you by the shoes that you're wearing, I don't think. But I thought the same thing. Bernadette was really waiting for the door to be open with that last witness. Yeah, it didn't quite get there, though. New viewer again. Dispose. Another question. DB doesn't know the difference between sounding confident versus arrogant. Skilled sophist versus abusive. Skilled legally versus being, well, a dick. Yeah, I think you were spot on there. Kat, this was as bad as when he asked forensics how headband got in the mirror. Yeah, my mouth dropped. We love you, Peter. Thanks for all you're doing for us. He walks right into it. And he thinks we learn a lot of this stuff in law school, right? Like, you don't try to out medicine a medical expert. You don't try to out science a scientist, right? You pick holes, and, you know, he tried to do that with who wrote the report. Oh, you know every word, how many pages in it. The judge kind of shut it down, but not like this. Peter Hambley, as a lawyer, does it feel discouraging to hear defendants choose to defend themselves? What motivation is there from them like Brooks did? I actually don't think it's that discouraging. I think this shows why you need lawyers, if anything else. And I think that Brooks did it because he either thought his public defenders thought that he was guilty, they weren't going to do a good enough job, or they weren't going to do the job that he wanted them to do. They weren't going to ask the questions he wanted them to do, especially with the sovereign citizen stuff. They weren't going to fight subject matter jurisdiction enough. So he said, you know what, screw it, I'm going to do it myself. I think that's the only reason I can really guess why he did it. Kat Yarb said, couldn't watch, but here for the recap. Ashley Casper Cox, what all in court is on the record? Him arguing with the judge, mumbling interruptions. So, yes, everything that's in court is on the record, even if the jury's out. It's still on the record. Now, him mumbling and saying things under his breath, that's harder because the court reporter has to hear it and be able to type it down. So that should be on the record, but there is a gray area there. Kelly's Corner said she'd argue the DA was telling Darrell Brooks, not the law enforcement officer. That's fine, but the law enforcement officer is on the stand in an active cross-examination, struggling back and forth with a potentially objectionable answer, not giving the answer she wants him to give, and she says it in open court for everybody to hear. Not the biggest deal in the world, but we're going to point it out. Ashley Harris, hey, Peter, watching your channel grow so fast is awesome. Sending a big, big welcome to all the new members and subscribers. We are so close to 150,000 subscribers. So if you guys could hit that subscribe button, that would be awesome. Tori File, I learned creative writing is something police officers do as well as DNA experts. Not all of them do. And the reason he was asking that question, I think you wrote this on Instagram as well. He was trying to say, like, oh, you guys are professional writers. Is that how you write this stuff? Or why are there typos or misspellings? There's always mistakes in police reports. I'm sure he found some and wanted to try to make a big deal about it, but that's all that was. Billy G, since Wisconsin doesn't have the death penalty, could Brooks have been tried in a federal court for any crimes that carry potential death sentences? I don't see a federal question here. They don't have subject matter jurisdiction, I don't believe. I guess technically some murders can be, but this is appropriately a state case, but it sounds like you might be with DB on the subject matter jurisdiction. I'm just kidding, Billy. Potentially he could have, I guess. Third, Wasson. I want to know what happens if more than 4 jurors get sick and have to be off the trial. If it gets below the minimum required amount, it could be a mistrial. My guess is Darrell Brooks is not going to consent to having less than the allotted amount of jurors. That is his right. Mo, as a potential juror, his points no longer sound pointed to me. He has worn me down. I no longer try to listen to him anymore. And I think this is consensus, Mo. If I would be willing to bet, I think that this is exactly how the jury feels. MVD, what's up? Not real question. Can the judge help create some app pertaining to patience? She would be an expert. Real question. What are all of the influences on the judge to be so patient and as neutral as possible? She doesn't want to, number one thing on her head is, I do not want to have to do this trial again. Number 2, I do not want to get appealed and lose. Actually, number 1 is, let's have a fair jury for justice fair trial for justice for the defendant and for the victim's families to get justice. That's number one. Number two is I don't want to have to do this over again. Azam, what's up? Yay, I'm here. For the record, I am a person. Another person said that as well. Hypothetical question. If the majority of the jurors are infected with COVID, are they going to call new jurors to continue this trial? Happy 145K subs. Thanks, Peter. No, unfortunately, they can't recall any old jurors. It would be a mistrial. We would have to do this all over again. So let's pray for the health and wellness of these jurors. Kayla, Peter, you're famous now. I don't know about that. Maybe an F- celebrity. Haha, do you think Brooks actually thinks he's doing well, or he's just being defiant on purpose? I think he's doing everything he can to delay and try to cause a mistrial, try to get held in contempt, anything he can have to not have this trial go to a jury verdict. Stina G, will his conduct affect his sentence, or is it purely based on charges? Also, is it common for the DA to try cases or just big ones? Big ones usually for the DA. And sure, it can have an effect on a sentence, but he's going to get multiple life sentences anyway. So at the end of the day, I don't actually think it's going to make that big of a difference. Joyce Brooks also finds herself yelling at the screen when he's disrespectful to the judge and agrees the judge needs to hammer him. I have been waiting for the judge to say, I thought she had the opportunity to say, oh, yes, somebody can tell you what to do as a grown man, because when you're in the position you're in, for the rest of your life, bud, you're going to get told what to do. That's what I'm thinking in my head. Brian probably shouldn't have taken his ex up on the hookup offer, nuts for the winter. Lindsay Liu, is the third-party intervener presenting on behalf of the defendant also violating DB's Sixth Amendment right to be present in court? He's trying to set it all up, and ain't none of it working so far, legally speaking, to stop this case. Hi, Peter. Why doesn't the prosecution object to DB's question more often? What's the strategy? They don't want to look like they're steamrolling him. They don't want to look like they're steamrolling him. They want him to be able to ask his questions if they are appropriate, and that's what they've done throughout most of this trial. All right, let's get to the next clip here, which is with this officer, I believe. 6:59. Yeah, this is when he starts to get annoyed. Let's do it. And I'll keep the comments and the new members, tons of new members, which is so awesome. Thank you guys that decided to join, or if somebody's gifting memberships. You guys are so generous, and it's a lot of fun, and it makes it worth it to do this stuff and talk about these cases, because when you guys join the conversation, add to the content, tell me what non-lawyers are thinking about these cases. As a trial lawyer, that helps me so much. We can learn from each other, and it makes it a lot of fun. All right, let's get to it.
Overrule, the witness may answer. It's redirect.
Yeah, so water pump, water coolant, it's all interchangeable as far as the cooling system for the engine goes. And the coolant system was low at the time of inspection and had been leaking, but from where, I do not know.
And again, does that control the steering?
No.
The braking?
No.
The acceleration?
No.
Finally, sir, you had talked about on cross-examination the presence of the high beams being on during the daylight. Do you recall that line of questioning?
Yes.
Specifically, you had indicated that sometimes the state patrol uses their high beams during the day. What was that for?
Objection. That was answered.
Overrule, the witness may answer. It's redirect.
To increase visibility.
Is that of any assistance if a vehicle is coming up behind people?
Objection suspected.
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled. But when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's.
So here's another opportunity for me to be fair and say, I have felt this way in a trial. Now, do I verbally make it obvious? Now, maybe you could tell by a look on my face or something, but I don't do it like he did. But sometimes it is annoying, especially as a criminal defense lawyer. when it seems like the state gets to do whatever they want and the judge is holding you back. Now, I can assure you that's not what's happening in this case, but I do understand why he feels that way sometimes, especially with different arguments and different objections. But he continues.
Funny.
Well,
I
sir,
really
I
do.
don't find it funny, number one. Number two,
You're not in my position either.
the court rules on the
True.
objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat.
For sure,
You
Shelley.
had questioned during the testimony of this witness, Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
You don't.
Right. And
You want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe 22nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point, the objection to not having an exhibit sticker on your report is not would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was. And the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination, you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it. I would just note two examples. You asked some questions regarding visibility and the impact of the high beams. That was one example. And then secondly, questioning him about the ball joint and whether it needed attention and what that would mean. And so I just wanted to
didn't come
make
from the report, Your Honor. The
a
only
record
thing
of
that came
that.
from the report was from page 9, when I was trying to get clarity about why it said worn tire tie rod.
Oh, and you actually questioned the
And-
witness about the different tire and what that would mean. So I thought three good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, from my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
You are, but you during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir,
Because I
you
don't-
say things like it's not.
Buddy, we do not have to write it down to prove that it's disparaging. Everything's being filmed and transcribed, but he acts like that's, again, she answers him. I would say, we all heard you, and just move on. Because when you can act like that to somebody, when they continuously try to test you just to be annoying, then give them what they're asking for. You don't have to tell him what the disparaging remarks are that he said. You don't have to tell him.
Fair, or you make noises that suggest like you're disgusted with the ruling that is made.
And Cindy, this would be the reason he testified. You're right, if he does.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's
you're
important
making an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling
Mr. Brooks,
disrespected?
I'm not going to engage in this
Because I don't think
back
you
and
did.
forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah, but
number
your
two, it's my
observations are
job-
incorrect.
It's
If
my
it-
job to ensure that under 906.11 that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the
You don't
record.
need to read it.
Under
You don't need to read
906,
it. Just make sure that
11,
you make a
The
correct.
judge shall exercise reasonable
Don't lie on the
control over the mode and order of interrogating witnesses and presenting
Don't lie on the record. But, man, that is so annoying.
It's
evidence
gonna
to
get
do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr.
Oh, Mr. Brooks, excuse me. Would you like some examples of how you were disparaging to people in the courtroom? Well, the judge may not have written them down, but I did.
Brooks' objections, his
I don't
response
think it's
was,
being
stop
caught
trying to be slick.
Yep, I did say that.
So just for the record, I thought that that was very disrespectful.
Thank you, I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
We'll
return?
come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard not
Because
to highlight
that's the
your
definition of trying to
misconduct
be slick.
during the trial. I'm trying my best here to
I don't see
frankly minimize
I don't
pointing
see
those
it.
things out to the jury and instead pointing
don't
them
see
out outside the presence of the jury. You may have noticed I even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your
I
conduct.
haven't noticed anything. And
There's lots of that, and they've been doing a lot of that to try to make it seem fair, try to make it seem the same, not highlight the fact that he is attached to the table and that he is a criminal defendant in jail. Like, they are doing a good job trying not to do that, and we'll hear more of that later. I think I put a clip in here about what they're doing with the evidence and with the witnesses to make this all seem normal. And I got to be honest, I've tried lots of cases and watched lots of trials. I didn't even notice what they're going to bring up later until she said it. And I was like, you know what? That is actually a good idea. They're really protecting the optics here for Darrell Brooks, no matter how much he complains about those exact optics. Let's answer a few questions before we get to after this break, which I will jump ahead to here, but not yet. Let's answer some questions. Ashley, how does he testify if he chooses to without saying his name and spelling it for the court? What name does he use? Ooh, maybe this is the reason he won't testify. Chloe Roberts, why don't they just match his DNA to the car? They did. They matched his DNA all over the car today. Andy Sturkowitz, can you explain the appeals process at all? Is there any realistic chance he has legitimate ways the verdict to be overturned? He's definitely going to appeal. There will be appellate issues. Nothing has happened so far, in my opinion, that makes this a reversible error where this would actually get reversed. It is very difficult for criminal cases to get overturned on appeal. I don't think there's been anything anywhere near him being a successful argument to reverse or overturn a guilty verdict if one comes. Hillbilly on TV. If I was him, when the DA came out, the DNA came out, I would have asked the judge if I could take that deal from the state. I mean, but realistically, 6 life sentences versus however many life sentences he ends up with, big deal. Who cares? Kim Ripley had an interesting question. It's a great point. Couldn't it be federal under interstate commerce because of the use of his car in the crime? If parts from the car came across state lines, use of a cell phone is how a lot of sex abuse cases go federal under interstate commerce. I don't think they would necessarily take that angle, but there are angles that this could have become federal. Usually they give state the DA the first dibs on this. It affected the members and the citizens of her county. It makes sense for her to get justice for her county, especially when something like this happened. This is the right jurisdiction for this case. This court, this judge was here for such a time as this, in my opinion, because this is difficult. This is really, really difficult. But thank you for the comment, Kim. And yes, there are always ways to make a case federal. Always ways to make a case federal. And we've seen some cases where there are state and federal charges for the same series of events. All right, let's listen to some more of this.
And thank you for a little extra time here. I spoke with the defendant about his witnesses for tomorrow, and I believe he's filling out the paperwork that I asked him to so we can get his witnesses here. I can tell the court this. I have 2 crime lab analysts to testify yet this afternoon. They're both here. The next one is from the Milwaukee lab. The second one's from the Madison lab. So if we could complete their testimony today, it would be greatly appreciated. I don't know how late you intend to go today or how long it will take, but I'm being optimistic. Our final witness would be a recall of Detective Casey briefly for some follow-up matters, and then we would be in a position to rest. I don't hold out hope that we'll probably be able to rest yet this evening, but maybe.
And they didn't end up resting today, in case anybody didn't catch that. They're going to try to call Detective Casey the next day. There could be issues with that. Darrell Brooks appropriately objects. Why not? Try to object. They already called him. Why do you need to call him again? If he's still under subpoena, they can call him. If they don't call him now, they could call him in the rebuttal case. There's a reason they want to call him. So they're not overly confident. They don't think it's a done deal. The state is doing everything they think they need to do to win this case.
Maybe, depending on how late you go and how smooth things move along.
All right, thank you. I appreciate that information, and I appreciate the parties discussing off the record some of the issues related to the defense witnesses. So that's great to hear. I can go a little bit later tonight, and I would say no later than 6. But if need be, if we can get through those 2 witnesses and Detective Casey, that would be great. But let's see how we go.
Okay, thank you.
All right, sir, did you have anything?
Yes, I do. Detective Casey already testified. What would be significance of him testifying again?
Well, let's take that up later. I want to deal with the lab analysts who are here first and not delay their testimony any further. So other than that issue, do you have anything else?
Yeah, I thought he was released from his subpoena. At least that was my guess.
I honestly don't recall whether that question was asked of me. I know he's the court officer and he's been here. I'd have to take a look at the record from when he testified and see if there was any reservation or have the state make an offer of proof, and we can go from there, but I'm not going to do that right now. I want to have those lab analysts testify they're here, and we can take up more fully the issue with Detective Casey after they're done testifying.
So how late do we plan on going?
I will go as late as 6 o'clock if need be. So I want to keep pushing along. I want to.
Yeah, that's definitely pushing it here.
That's not that late, sir. We've stayed to 5:36. Previously, there were times during jury selection we stayed till probably 7 or 7:30. The last 2 nights we did break at about 4:30, 4:45, and so I'm willing to go a little bit later tonight. So it's 3:30 now. We'll see how things go.
I was making that saying that on the record because in my position that is kind of late.
Well, let's start now and we'll get going.
And I will just tell you, so this is interesting, right? Another argument I'm going to somewhat agree with Darrell Brooks on. Now, I know why he wants to make this argument. He wants to delay. He wants to frustrate the process. But as a pro se litigant who's prepping your case from jail, it's a lot more difficult. And I don't think it's, unreasonable for him to want to stop at 6 or even 5:30 so he can go back and eat and prep and be ready for the next day. He's calling witnesses for the first time in his life. So the judge does need to be careful with scheduling. Now, the judge controls the timeline of the courtroom. They can make us stay late. They can make us work overtime. But I will just tell you right now, if I push a judge, me personally as a private criminal defense lawyer, not even somebody with the rights of a pro se litigant, I am constitutionally protected in the criminal defense cases. But if I say, judge, no, we got to stop at 5 or we have to stop at 5:30, usually a judge will agree to that. Because if we have real reasons we need to, prep reasons, trial reasons to make this a fair trial, usually they will. But this judge knows exactly why Darrell Brooks is making this argument. So even if the argument could be sound, the reasoning is not. And this is why when you're being frustrating and annoying all trial, how it can actually come back to hurt you. And I think that's exactly what happened to Darrell Brooks here. All right, they bring in the crime scene boss guy who got the U.S. mail with Darrell Brooks' name on it, his address on it. And that is when we have the outburst of the night. But before we get there, let's answer a few more questions. KWNY Upstate, did the car have a fully mechanical breakdown system or is there any computer control based on tidal decompression? Could he argue computer malfunction? According to the accident reconstructionist and mechanical expert they had, no, there were no mechanical or computer control problems with this car. Mecca 101, is it possible he came up with the sob sit stuff concept in jail? I think it is possible. Rashenda, I saw a couple of people say, ever tried running in flip-flops? It's a good point. Do you remember he told this from Paula Graham? Do you remember he told the cops he had Green Bay Packers slides? Lie number 89. Yeah, be honest with the court, somebody else said. Diana B, flip-flops have the same game team as hoodie. That's why he dumped them both, I bet. Oh, okay. What influences the judge's decision to be so lenient? I believe we answered this. This guy was a jerk the whole time. Yeah, it does factor into it. And the appellate court can read this and see this case. They've probably heard about it, and they're human too. Linda K, think the jury would go not guilty if he's able to give doubt about his arrest, detainment, treatment, or technicality? No, because those are questions of law, and the judge is not going to allow him to really argue that they violated his Fifth Amendment right, or she would have thrown out those statements, or if you want to call it a confession or anything like that. Clinton Porter, new member here. Hello from Texas. Due to my limited experience as a professional Google lawyer, I appreciate your legal analysis on this case. Thank you, Clinton. Cassandra, I listened to the trial today, and just listening to how excitedly he said, "Are you holding me in contempt?" told me everything I need to know. He's simply trying to delay the inevitable, and we're about to hear that. Catherine, if he is found guilty, does this judge do the sentencing? Yes, she does. JMB, I think he ditched the slides because he had socks on and it would be hard to run in them. Maybe. You guys are smart. You guys are smart. I love it. And see how many of you guys think the same thing? Jono, during the AHJD trial, there was a break of a week. Could the trial judge take a break for a week due to COVID rather than a redo? Miss Doolittle thought the same thing. Could the judge break for a week? There's a lot of scheduling issues that could create a problem with that. Darrell Brooks potentially could object to that and ask for a mistrial instead, which could create that could be a real appellate issue. Is, you know, the week off, if everybody's going to go see the media and people on YouTube talking about this case, it's going to create problems for him. He could make that argument, and then the judge will have to make a call. Olini, when is the state going to talk about the 6 deaths and multiple injuries? It's worrying me. They have talked about this. They have talked about this a lot. The medical examiner came and spoke about how the injuries on the people that passed away. We've heard from people that were injured. Darrell Brooks even called one of the people that he injured in the parade. It's been wild. Tessie Turner, what happens if he doesn't have all witnesses in court? They'll call him out of order or try to get him there when they can. I don't think this case is going to end on Friday, so maybe they'll try to get anybody that can't come in on Monday. But if the state tries, that's all they have to do. They don't have to absolutely make sure all of them show up. My guess is none of them are actually going to be good for Darrell Brooks, so I think the state's going to do everything they can to get him to show up. Sue, being a federal warden, that's cool. He is getting help from a jailhouse lawyer. He will have a tough time in prison. MVD, is there not a mechanism to proactively shut down repeated objections motions, subject matter jurisdiction, so the court doesn't need to keep revisiting the issue? Yeah, you can literally bind and gag him, which I would never say to do, and I think is horrible and wrong and unconstitutional. But what is constitutional is put him in another courtroom, let him watch and listen to the whole thing, and mute him. He's not going to interrupt and disrupt this entire process. He's not going to waste the jury's time, the court's time, law enforcement officers' time, witnesses' time. Jenna, can there be a law that will keep defendants from appeal if they don't able or abide by the law and lawful behavior in their first trial? No, you don't want to get rid of appellate opportunities, because there are only certain reasons why you can appeal, and very limited appeals get granted. So to limit that even more, to add on, to me, is not something I think would be realistic. Joe Gottman, could he be fined every time he talks back? That's if she holds him in contempt and sanctions him, but that would delay the trial. She'd have to make certain findings. She doesn't want to do that. BC, well wishes from Arizona. This trial is maddening. Entire courtroom is handcuffed versus the defendant. His disrespect to the judge, attorneys, witnesses, jurors, and victims' families is despicable, and I agree. Tori, I love that he says he wants the jury to know the truth, and they have a right to know. Fine, let's put prior bad acts in, Mr. Brooks, right? He doesn't realize how much she is helping his case. Right, and how much the truth sometimes doesn't come in because it's inadmissible, like his prior bad acts. There are reasons, legal reasons, evidentiary reasons. Those do not come in. Great point, Tori. This cuts both ways. The whole truth never comes in at trial. Let's be honest. The truth should come in, and nothing but the truth should come in, but the whole truth does not come in. Nobody's promised that, unfortunately. Carrie Staley, I forced myself to watch all day, and what a day to watch. Joined the Yell at the Screen Club. He's infuriating. Makes me wonder how differently the trial would have gone with real lawyers. It would have been very different. And go ahead and hit that like button if you yelled at the screen today. Third, Wasson, I'm from Wisconsin. This case is disheartening. Makes me wish I would have went into law instead of medicine. Love your content. Thank you so much. And I keep saying third, Wasson. I realize it's T-Bird, but sometimes my eyes and brain just, you know how it starts to click, and I've seen your name so many times and it pops in as third Wasson. So I apologize for that. Like the judge, I don't mean any disrespect by calling you the defendant or Mr. Brooks. Zosh Apple, do you think it hurt to not have a more visible proof of injuries to the crowd? No. And I think some of the videos we're not seeing are him literally running over people and hitting people with his car. And I don't think we're seeing those videos. So I think the jury is seeing more than we are with that. Cat Yard, Peter, why are you sitting in the dark? I'm trying to make it so it's not annoying for you guys. Is this an annoying kind of view? If I have lights on behind, there are lights, all the rooms around me have lights on, but the room I'm sitting in doesn't, because I feel like it's easier for you guys to see, but I could be wrong. Matthew Self, can't wait to see you on the Drew Kita stream. So this is funny. Nick messaged me today. He forgot to send me the link, which is no big deal. I've been slammed with this trial prep, but it's going away. So I am going to try to go on Nick's channel tomorrow. I think he streams it on a different channel on Rumble. I've never been on Rumble, so it'll be my first ready to Rumble stream. But he said he mentioned something, and there were some interesting discussions after he mentioned my channel. So if anybody came here from that stream with Nick, thank you. Let me know in the comments if you did. Larry S., with all the evidence, it's a slam dunk now. I think it should be. Jason, is it bad optics that the judge looks flustered when he apparently gets to her? No, anybody would. She's a human being. Patty Joe, seems like Brooks totally doesn't understand the meaning of each objection type and feels like he's rolling the dice and picking a random objection blatantly. He's clever and slowly learning, but that won't help him save himself here. I agree with you. This is a perfect assessment. He has no clue what he's doing half the time. Then he starts to figure it out, like leading questions and hearsay. I think he is starting to figure it out, but it's a little too late for that now. All right, let's get to the real fireworks of the day. 8 hour and 5 minute mark. This is where I was very frustrated, and I can understand why people want to take rights away from people, even though I don't agree with it. You can start to understand why people start to feel that way.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent
witness
to being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do
I'm
not
not
interrupt me.
So I don't know if I missed the beginning part where she already explained that, but she's basically saying the reason there are documents up at the stand is because in a normal trial where we don't have the defendant with the zap things on his legs or, chained to the table, you can approach the witness and hand them a document to look at. We can't do that in this case. Actually, the state could, and I could let them do that, and you wouldn't be able to do that. So they would know that you're probably shackled to the table. Instead, we're trying to make this look fair. And I didn't even notice that nobody was approaching the bench because I knew they were showing stuff on the screens. But when they did have to give a document, they just put it up there before the witness got there. So the jury didn't even notice that the defendant can't approach the stand. Again, something they are doing to help him that he is complaining about.
Or you will
I'm not
forfeit your
entitled
right
to
to
know
be
how I got
present in
there.
this courtroom.
So
Do
you're
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm going to make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
This literally sounds like me to my son, like, all right, that's it, dude. Now you're in trouble. If you do one more thing, you're in trouble. He does one more thing. All right, now you're in trouble, dude. Unless you can promise me you're not going to do another thing. That's what she did. She literally told him not to do something multiple times. He did it again. She gave him one last warning. He did it again. And then right before she's about to kick him out, she gives him one more chance, and he starts to calm down a little bit.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus
I
Allen.
didn't forfeit
I'm
anything.
going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could
Everybody in the courtroom's like, he's done it enough, Judge. We're ready to take him out. She's like, well, just wait. He hasn't interrupted me now.
approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly, under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at.
Listen to these disruptions, and he's still in this courtroom. And she just has a slew of them from today.
9:03, 4 at 9:04, 1 at 9:05, sorry, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05. There was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19. Audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as
She doesn't mean an actually funny comment. She means he sarcastically said hilarious.
arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard. And I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
Here's the point. He knows at this point, and I really, really like this judge. I can't compliment her enough, but at this point, he knows that her threats are a bit empty. So she's saying stop or else, and he's going to go with or else, and he doesn't get thrown out.
And I'm not stopping you
Through
from
your
doing that.
behavior, you're not going to delay these proceedings today.
I'm not trying to
We're
delay the
gonna
proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to
bringing
do.
the jury out. I'm not going to argue with you.
Then don't, because I'm not arguing with you either. I'm stating
You're
facts.
raising your voice. It's
Because I'm tired of you always making a record. You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately.
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being
I'm
able.
advising you to be quiet because the jury's coming back.
You're advising me to be quiet. Is you telling me to be quiet?
To be respectful when the
Are
jury
you telling me
comes
to be quiet, or are you asking me?
out. I'm asking you and advising
Okay,
you.
thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate.
We're all
if you lower
we're
your
all
tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to do
sir.
anything at all.
Sir, I'd appreciate if your tone of.
Like, he's delusional. Like, you are a criminal defendant here charged with multiple murders, and you're patting yourself on the back for not telling a judge what to do in the courtroom. You know, the saying even Job would take a swing on you was built for this.
Voice switching.
I would appreciate if you asked me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you asked me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All right for the jury.
Not gonna work. I'm supposed to be scared of getting removed or something.
Like, I'm supposed to be scared of getting removed or something. I hope the court reporter's writing all this down. He's not scared of getting removed. No, nobody's going to tell him what to do. Nobody's going to tell him he can't talk. That's literally what a judge just said. We got big shot, big time professional private criminal defense lawyers that judges tell to stop talking all the time. The judge is the king or queen of the courtroom. Like, come on. It's not disrespectful. It's literally their job. And she's trying to help you out by telling you to stop talking so the jury doesn't hate you. Like, that's literally what she's trying to do. And John, I think you're right. But I literally just, this is the type of stuff to me that is mind-boggling. Literally mind-boggling. I agree. I mean, I think she needs to toss him, personally. I mean, I really think. JRR, can you explain what a sovereign citizen is, and is it a real thing? I mean, it's a real thing. People believe it. They don't believe that the state law, they're a sovereign citizen of the United States. They have different beliefs. They don't think anybody can do anything to them. They don't believe in the authority of law enforcement or taxes or jails. It's like, well, you can still go to jail for not paying taxes, and you can still go to jail, as you see here with Mr. Brooks. And some prior videos, I broke it down in more detail. Gabrielle, why isn't the state calling the families of the people he killed? Is it because they have enough proof they're saving them the grief of testifying potentially? I know they've had some testimony about it. I can't remember if they've had any family members. I know they had the medical examiner there, but probably that goes into it. You heard what from who? Does he want the delay simply to stay in the county longer instead of prison and keep the potential for a mistrial going so they have to do this all over again? Holy cow, we are so close to 7,000 people in here. That's fun. This is the biggest live stream we've had during the Brooks trial. So hit that like button. Let's get the most likes since we've had during the Brooks trial. And there's got to be some new people here that haven't subscribed. So hit that subscribe button and reminder bell because we're doing recaps every night. And Darrell Brooks is going to start his trial tomorrow. And we're getting overtime. Usually my streams are about an hour. We're over an hour. We're overtime again. So hit the subscribe button for some overtime. Did you catch when he asked why the analyst only used forensic techniques and not 5 or 6 ENSIC and totally slammed those witnesses? I'm a little slow. Excuse me. Bobby Cat. Hello, Peter. Do you think the reason he decided to go pro se is because an attorney told him there's no way he could win? I just can't see it for another reason. Or that what's more likely that happens, and sometimes what clients argue with us about in the past, is we will not make certain arguments. I am not going to make certain arguments. I am not going to ask the judge every time we start court for subject matter jurisdiction. I am not going to tell the judge she's lying on the record. Sometimes clients or the criminal defendants want you to do that, and sometimes they represent themselves. Zerg, has he been in protective custody the whole time? He never pulled sob-sit stuff when arrested. Maybe he was just shook. I'm not sure. Zerg, again, don't defense attorneys usually not cross victims? No, they do, and it can be very difficult. You have to be very careful and very respectful, but they do. Kimberly Conroy, does DB have to pay to file an appeal? An appellate lawyer will be provided for him. And most of the stuff, I think they charge him like $75 or something, but I think he pays it by working in prison. Kat Johnson, anyone catch the blood on his hoodie sleeve was Miss Patterson's on the same side? She testified that he hit her in the car. I did not catch that. But I've been listening a lot more than I've been watching. I have watched some of it as well. Michael, will he be allowed to take the pauses to read statement/notes on direct? What could the judge do? Is there something like 906.11 for direct? No, he'll be able to take his time going through it. Direct, frankly, usually takes longer than cross. It wouldn't surprise me if DB is from Patty B, photographer. If DB called Your Honor to the stand, he has that much disrespect and shows that much disrespect for the whole trial. It wouldn't surprise me if he tried to call anybody, the president of the United States, to say he's a sovereign citizen of the United States only. Michelle Hornbacker, why does he keep trying to get the witness to say that the state of Wisconsin is not a human? Well, hold this thought, Michelle, because he finally gets what he wants in his aha moment here. That's the last clip we are going to play. Apple Jam, if they lose too many jurors and a new trial is needed, could the judge then find DP not competent to represent himself based on prior behavior in court? No. This behavior is not incompetence. This is purposeful. This almost proves his competence, if I'm being honest, as sad as that sounds. You heard what from who? Would love to see another collab with Emily Baker, considering her background as a prosecutor. Yes, I've worked at the prosecutor's office. My dad was a state and federal prosecutor. So we like seeing it from both sides. Would love to have Emily Baker on. I've actually never done a stream with her. We did that thing for the California Bar Association. I've never had her on the stream. Always an open invite. Would love to have her on. I love talking to lawyers about legal stuff, So it's always a lot of fun. Tori, he literally used that same car and ran over his ex and broke her leg. That's the Breyer Brad Act, the motion limited to keep out. So let's keep it fair and let the jury know everything, right, Mr. Brooks? Tori's hammering him tonight. She's coming out swinging. Stephanie, like I'm supposed to be scared, etc. Symptoms of narcissism, grandiosity, and entitlement. And like so obviously where you have no leverage in this situation, but no leverage. My students are back. I'll join the rewatch crew. Azam, thank you for hanging as long as you did. I know this is longer than I usually am on. Azam's only used to 1 hour. Stephanie, wonder if he will open that door when questioning his ex. He's losing his control a lot faster. The DA is closer to resting. I hope the DA slams him. I think they're going to do everything they can to help him not open that door because they don't need him to open that door. A. O'Connor, he is a product of his environment. This is how he was taught throughout life lessons to behave, to argue everything on your behalf. He has no self-esteem because he wasn't taught to be an individual. I have a whole stream that won't fit here. Yeah, I mean, he thinks he's being an individual with the sovereign citizen stuff. He thinks that's a very individualistic and forward-thinking way to live, but it's not working in this situation. Christine Madrashin, why couldn't they just use Zoom for the jurors? There are confrontation clause issues with that, and all criminal defense lawyers are trying to block that because that is not what you want to do. That is not a fair trial. There could be people going on in the background. We won't get there. Leah French, he will rumble on opening. Can the judge interrupt? Yeah, he said There's no telling how long opening is going to be. And the judge tries to explain to him the difference between opening and closing and how there can't be an argument. But let's get to his aha moment. And it figures it comes with the gator on the stand. Now, obviously, this guy is smart. He's the DNA tester with his, his master's degree and whatever. But he went to the University of Florida. Can we really believe what this guy says? Obviously, I'm just kidding. But he does give Darrell Brooks his aha moment, what Darrell Brooks has been looking for this entire trial. He gets it. He gets it right here. And we're going to see him get his W, eat his W in court right here with this witness.
Ever directly talk to the plaintiff in this matter?
Don't know how I would talk to the state of Wisconsin.
Can you repeat that? I'm sorry.
I do not know how I would talk to the state of Wisconsin. It's an entity, not a person.
Not a person, right?
Boom! He did it. He got somebody to explain what he's been trying to say this whole time. You can't talk to the state of Wisconsin. They're not a person. Boom. Okay, and is that supposed to win you the case, Mr. Brooks? Because I don't think it did. Leslie P. said her super chat disappeared. I'm not sure we have a lot of super chats. If we missed it, hopefully John can go back and grab it and star it for me so I can try to answer that. Ashley King, show the look he gave her after keep playing. Sorry, yeah, he gave her so many looks today. He went street on her, Kelly said. Stuck at home with COVID, Megan writes, said, hopefully you're not a juror in this case. Thanks for your coverage. Hopefully you feel better very soon, Megan. All right, I am past how long I need to be here. Too much work, too tired. I need to get some rest. So I am going to go through as many questions as I can for the next 8 minutes. So we have 8 minutes. I'm going to answer as many questions as I can. If I don't get to them, I apologize. I know a bunch of people were telling me some super chats came in after I signed off. There's nothing I can do about those, unfortunately. I posted one that came off as I was hitting sign off and saw it, posted it on our community page to answer it. I answer all of them I can, as much as I can, as thorough as I can. You guys know that's one of the big things here is to try to answer questions. So I'm going to answer as many of them as I can right now. But hit that subscribe button if you haven't already. We didn't quite hit 7,000, so it gives us something to shoot for tomorrow, which is good. 7,000 people in the chat. So subscribe. Come back tomorrow, please. Hit that like button on the video if you haven't already. But let's get to some questions. He says he doesn't tell her what to do, but when he insists she answers all his questions, he is telling her what to do. Well, he's being disrespectful. That's even worse than trying to tell somebody what to do. Diamonds and doggies. Any stipulation on his opening statement tomorrow and the time constraints? It doesn't seem like that. She seems like it will be 8 hours of monologue if there is no time rules. She said she would cut him off if he argued about the plaintiff or subject matter jurisdiction or his Fifth Amendment right or made arguments at all. So I do think there will come a point where she does cut him off. MVD, how do you think the prosecution is processing this circus? In law school, is there any training on anything close to this? No, they do not train us on how to deal with pro se defendants. But now that we have like a full trial and videos that you can actually show, I think it will help young lawyers. Because when I did it the first time and only time, it's really something only prosecutors deal with. But when you do deal with it the first time, it's very difficult. Very difficult. Cordoba, what's up? He has no respect for females and the judge is one. It doesn't seem like he's got respect for anybody. Elijah Timmons, the state's case is all right except for motive. It makes no sense that a guy who beats up his girlfriend for years goes toward the police while trying to flee. They are avoiding his Facebook comments. I actually agree with you. Motive, I don't agree with you that the prosecution has a hole in their case. I think their case is strong. You don't have to prove motive to prove this case. But I don't know why he did it. It is weird. Why would he do it? Problem is, we know he did it, right? Based on all the evidence, the videos, the pictures, the DNA. To me, they're proving their case beyond a reasonable doubt at this point. I do feel like they are proving it. LB Mesmer. But tomorrow, we're actually going to talk about what did the prosecution prove with this case, and we're going to go through that. I simply don't understand how he can get away with that blatant disrespect. It blows my mind. That makes two of us, LB. RRSTTT. I think he's going pro se because he knows he is going away for life and he gets to make a name for himself. So many people talking about him, and he's definitely putting on a show for the cameras. Ginger Snap Girl. What is his defense? Is he saying he didn't do it? He's saying It wasn't him. And if it was him, there was somebody else in the car with him. But if it was him driving, there was a malfunction in the car. He didn't try to hit anybody. He got stuck in the parade and couldn't get out. Those are all the arguments he's made so far. Kelly, I thought early on he was trying to prove the police and court wasn't treating him as an innocent until proven guilty. But as crazy as it all is, this is his last chance to save his own life. I agree. Katie, we broke 6.5K viewers. Yes, we did. That's crazy. And thank you for being one of them. Christy, there is no way he would have been able to sit quietly if he had lawyers representing him. I wonder how that would have gone. Well, go back and watch some of the hearings. It's brutal. Brutal. Matthew, I bet the DA prepped him on that and gave him that answer for the jury. Oh, are you talking about the officer again? You might have been talking about the officer. William Moa, do you think there will be victim impact statements during this trial process, or is that something that happens for sentencing hearing? I think we'll see victim impact during sentencing. Usually that happens during sentencing because it doesn't necessarily go to prove what he did, but how it affected him and how and why he should get the worst of all sentences. That's what victim impact is really for. Citizen X Thursday is going to be fun. We're going to see what he does. People are asking, who's he going to call? What are they going to ask? Stace on the case. Tomorrow is the members only chat. No, not tomorrow, next week. We will do the members only chat next week. We're after the Brooks trial. We're going to be hitting Brooks trial while it's going on. Next week, we'll try to do either next week or the week after. I'm going to do my best. You guys know, working full time, full caseload, real lawyer, because I try to bring what's happening literally right now in courtrooms to you so you can understand the process better. We want a top 10 Darrell Brooks highlights. Ashley can go to 8/12/45. Watch that look. Okay, let's see it. 8/12/45. Let's share the screen here for Ashley.
What you asked me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All right for the jury.
Not going to work. It's supposed to be scared getting removed or something.
It's amazing how much you can tell from somebody just seeing their eyes, right? Yeah. Not a great look. Not a nice look, that's for sure. Definitely not a nice look. It's when he sits down. Okay, all right. I'll leave it on. What's up, Kaylee?
Thank you, everyone. Please be seated. State may continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we have 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
It was a long look too. Not just a mean one. Question. Sorry, let me get this unshared here. So if I'm Lori Vallow's lawyers and I want to keep cameras out of the courtroom, then I'm showing this video of how they zoom in to the defendant's face. They make it about him, and every look that he makes and everybody's commenting on it. And that's why they don't want cameras in that case, because Lori Vallow and Chad Daybell, well, Chad Daybell wants cameras, but Lori Vallow is not trying to make herself famous off this case as a criminal defendant like Darrell Brooks is. That's probably what she would argue. So, yes, it was long and awkward. Yes, I am on 1.5. Yes, I understand that. And I understand the frustrations, but I'm so far past the time I try to keep this at. Let's hit some members here. We answered 8 minutes of questions. Ann Wolf, Darcy, Jeremiah, and Katie Fisher, the 2 for 1. Holly, Kelly, Nunya Business, and Vicky are all new members, which is awesome. They're here in time for the members only chat we're going to do next week. We'll talk more about that. I appreciate all of you so much. You guys are the best, literally the best community and chatters and questioners and potential jurors. You're the best. Thank you so much for coming. Hit that like button. 6,000 of you. Hit that like button on the way out. Tell your friends about it. If they want to watch a recap, get their questions answered, come watch the rewatch crew and come tomorrow night. Appreciate you all. You're the best. Marty, dedication. All right.